You know, you all started this morning. You got quiet right away, but now you're taking your time
It's funny.
when it's time for a panel discussion. I don't get it. Um, I used to get my students to be quiet by saying, "Okay, now I'm going to tell you the answers to the examination."
Yes, indeed.
But it doesn't work on this group. So obviously, the problem with all of you is that you have too many friends in the audience, and you realize that it's much more interesting to talk to them than to listen to us. But this panel will hopefully be as interesting as the other two, and as Slade Bond was. I hope you realize that we do this under the gaze of Justice Brandeis. I hope you saw his portrait outside.
I love it. I love
So he's watching. Um, This is a panel on remedies, as you know, and I want to start out by reading to you something that Justice Robert Jackson wrote in the International Salt case, 1947 Supreme Court decision. So in that decision, he rejected a narrow remedy that International Salt was complaining the remedy was too broad. And he rejected the idea that the remedy should go no further than the violation or threat of violation. And he wrote, in an equity suit, the end to be served is not punishment of past transgression, nor is it merely to end specific illegal practices. A public interest served by such civil suits is that they effectively pry open to competition a market that has been closed by defendants' illegal restraints. If this decree accomplishes less than that, the government has won a lawsuit and lost a cause. So, what we hope to explore today is the real challenge. I mean, I love talking about the economics and the legal theory, but in trying the case, the real challenge, I think, is, so what do we do about it? What's the remedy? The real challenge is that the lawyers and economists who won the case don't end up losing the cause. And I want to juxtapose that against some of the things the Court of Appeals in Microsoft said in the appeal, whose 25th anniversary will come one day, said that the remedies have to be tailored to fit the wrong, and when the remedy provisions are forward-looking, a district court's discretion is necessarily less broad, that's a quote, because the court can't be sure it won't be preventing the defendant from choosing new routes to serve consumers. So, a little less, shall we say, government or plaintiff-friendly language from the Court of Appeals than Supreme Court language from the 40s and the 50s. So some of our questions for the panel are going to be, can we sketch out the range of possible remedies in this raft of monopolization cases that are now winding their way through the courts? Will these remedies meet the standard that the Microsoft Court of Appeals set out in being tailored to fit the wrong? Will they be too perhaps disconnected from what was proved? Will they meet the causation standard that the Court of Appeals suggested? How practical are they? The courts are very concerned with whether they can manage the remedies. Are the remedies that we in our infinite brilliance can come up with ones that can actually be managed and be effective? Actually, working off of the discussion from Slade, is litigation even the way to go on this? Is this the best way, if we have competition problems, to remedy things? Is a legislative approach better? A more regulatory approach better? So we're going to try to talk about that. And Slade's final comments about the states. We don't want to forget that the states are involved in these cases and may have different views. So, And again, touching back to Microsoft and to politics. As the Microsoft case was being litigated, everyone in the case was aware that there was an election coming up and that there was a strong chance that, what was his name, Gore? Might not be elected, and that it could be George Bush, and that things might change. And that led to different strategies from the parties, particularly from Microsoft. And it didn't so much affect the argument in front of the Court of Appeals, which was done mainly by career people from the Solicitor General's office. And I must say, those of us who were listening to that argument were quite surprised to read a unanimous en banc decision coming out as a result of those 2 days of argument. So if everything seems foreordained as we look back on it, hey, it wasn't. So we had that, but then of course there was an election and there was a settlement, and things changed. So politics was not out of the case in Microsoft, and it's certainly not out here. So if it was uncertain then, do you think things are uncertain today politically? No, don't answer that. Please don't answer that. So I don't want to put the panel in the position of prognosticators. So I want to put this out in the sense of what are the range of remedies. And I want to read a portion of the transcript of a Face the Nation interview that Margaret Brennan did with Vice President Vance on January 26, 2025. So it's fairly recent. Vance is a fairly high up person in this administration. That was the last question of her interview, which was a long interview. And she said, raised a question about big tech. And she said, in August, you told us Google and Facebook are too big. Quote, we ought to take the Teddy Roosevelt approach, break them up. Don't let them control what people are allowed to say, close quote. It's a quote from Vance earlier. They've now donated to the Trump inauguration. Are you still going to break up big tech? She didn't have the picture of them standing there, I guess. And Vance replied this way, quote, we believe fundamentally that big tech does have too much power, and there are 2 ways they can go about this. They can either respect Americans' constitutional rights, they can stop engaging in censorship, and if they don't, you can be absolutely sure that Donald Trump's leadership is not going to look too kindly on them. This was not Gail Slater talking. This was the Vice President of the United States. So she said, so they're still on notice. And he said, they're very much on notice. So my question is not what do we take this to mean, what's going to happen and so forth, but a more targeted question, whether in thinking about remedy, whether viewpoint discrimination by any of these defendants, this would be particularly Google, I guess, but also Facebook, is a valid goal of remedy. And
No.
is it...
Sorry. Sorry.
I didn't think this was a rhetorical question. I thought it was one for discussion. But I want to hear, I would like to hear, everyone has things prepared, and we're going to talk about that. But I would like to hear what are, in a sense, what are the goals and why that is or isn't a valid goal. And should it be approached as a conduct, if you wanted it, as a conduct or a structural remedy. So I throw that out as part of the political stuff. Let me just briefly introduce our panel. You have their, I guess, their affiliations. And we're going, introduce them in the order in which they'll do their initial interventions. Fiona Scott Morton, Theodore Nierenberg, Professor of Economics at the Yale University School of Management and an adjunct professor at Yale Law School. IO specialist, we know her well, She has been chief economist at the Antitrust Division, writes a lot in this area and in antitrust generally, very active. And she founded and directed the Thurman Arnold Project at Yale. And I guess that's a good branding example of the label tells you everything we want to know. Randy Picker, second, James Parker Hall, Distinguished Service Professor of Law at the University of Chicago Law School. Currently teaches antitrust, copyright, and technology policy. And he's working on a book I love. He's got a great name, The Quest for Next. Sort of rolls off the tongue. So,
Good.
A little plug on that.
Say it as many times as you can.
The Quest for Next. The Quest for Next, a study of competition in the computer industry from World War II through the current era. Tim Wu, next to me, Julius Silver, Professor of Law, Science, and Technology at Columbia. Tim and Biden antitrust like this, right? I mean, it's thanks to Tim that we can say that not the only person, but really the force behind it, I think, that Biden antitrust sits with Thurman Arnold, Robert Jackson as great eras of antitrust enforcement, really extraordinary in terms of putting the president behind antitrust. And latest book is Tim has great, in case you didn't know, great titles. The latest book is The Age of Extraction, coming out in November of this year. It's not about dentistry.
Not about
Latest
oil.
working papers, antitrust is intellectual property.
No, it's industrial
Policy,
Thank
sorry.
you. Yeah, thank you.
I keep thinking of the IP stuff.
Yeah.
And I will point out, if there's any eminence grise that ties our speakers together, it turns out to be Richard Posner,
Yeah.
because we have 4 former Posner clerks
True.
So Randy, Tim, Rebecca, and Scott. So if there's anyone to blame for the leftward tilt of this conference,
That's funny.
it's Richard Posner. How's that? Sorry that Eric's not here. Okay, Eric Posner. Bill Kovacic. Bill is here. He is not in a foreign country, which is, I think, extraordinary. Global competition.
Depends on how you define here.
Yeah, well, I don't want to, we don't want to have to. Global competition professor of law and policy and director competition law center at GW Law School. Bill has held every position at the Federal Trade Commission. I was going to say except for being fired, but maybe that's coming. But former chair, former general counsel, former commissioner, and started out as on staff at the Federal Trade Commission, which is where I first met Bill. Really the person who writes about antitrust institutions in a way that I don't think anyone else does. And then we have a twofer at the end, co-authors Alex Destriel and Pierre LaRouche. Alex, professor of European law at the University of Namur, visiting professor of the College of Europe, and Sciences Po, and academic director at CER, the Center on Regulation in Europe, very well known, of course, and on the decision panel, Belgian Competition Authority. Pierre, professor of law and innovation, faculty of law, University of Montreal. Prolific writer in the area of innovation, and also has written about Microsoft, and formerly at Tilburg University, where he co-founded the Tilburg Law and Economics Center. So it's a really good panel, and we're going to start out with an initial intervention, about 5 minutes each, from the panelists, and then we'll mix it up with some questions. So,
Okay,
Fiona.
I'm first. All right, I'm going to open with an off-topic remark. Rebecca earlier said she was happy to be the one lady on the panel, just like Eleanor had been 25 years ago. I'm not happy to be the one lady on the panel. I think that we should strive to be doing better than that. So I'll just lay that down for anyone who wants to pick it up. Thank you. Good. So I'll just make a couple of points about remedies. I think it's just really important to hold in mind the incentive and ability principles that we carry around in antitrust enforcement, and that we saw in the Microsoft case. As an aside, before going into the examples that I want to look forward to rather than backward to Microsoft. I just want to go back to competition versus competitors, which again was the theme of the Microsoft case. When I listened to Daniel, it seemed that he wanted the Microsoft court to enumerate the benefits to consumers of every nascent competitor and existing competitor and measure them all and balance them. And that's, of course, impossible. So if that's your standard for what a court should be doing, what you're really saying is all defendants should go free. That's just a plan to let all the defendants win. And the same thing applies to remedies. You're not picking A should do this and B should do that. You're thinking about the incentive and the ability of the entrant to come in that you don't know about. So it's the same kind of problem, just in reverse. Now, incentive and ability can be achieved legislatively, and in fact, the Digital Markets Act in Europe has taken this path. So rather than have an antitrust case and get remedies after each one, which their tools are not so good at doing, they've just said, here's some interfaces, and we've got some interoperability requirements, we've got some data requirements, we've got some rights that are strengthened for the business users, the complementers on the platform. A second thing to remark about incentive and ability is that when we think about remedies, it's very common to say divestiture is really harsh and behavioral is really weak. And, we're going to have a neo-Brandesian sticker like Tim likes to have, break them up. And that's going to somehow signal to the community that we're being really harsh. But that is actually not true. Like, if I suggested to Amazon that they divest AWS by selling it, I'm not sure that that would diminish total profits at all. Whereas if I told Facebook they had to be interoperable, that would probably diminish total profits a lot. So one's a structural and one's a behavioral, and you can't just line them up all the way in that order. It depends what you're asking them to do. Okay. So the main point that I'd like to make in incentive and ability is that what you're trying to set up is a new environment, and that means that creativity is a giant problem. We don't normally have a creativity problem in cartels because if the cartel is charging 100 when they should be charging 80, the remedy is stop colluding, and we can exactly foresee what the market will look like. The price will drop to 80. In a merger, we don't need creativity because we see the but-for world right in front of us. The parties have not merged yet. And so you don't have to convince the judge about what's great about not having merged firms. They're not merged right now. In a monopolization case, we're explicitly trying to create a world that does not exist. It's not the thing in front of us, and that is a tremendous barrier because most people don't have the brain space to think about what they could have when they don't have it. It's like the Model T Ford. It's black, there's one car, it's great, it's a car, isn't that exciting? And nobody thought there could be a red car or a white car. Just like Google saying our search engine is the best and nobody can think of another kind of search engine because they haven't ever seen one that was differentiated. So that is tremendously difficult. Then on top of that, if you introduce something that's going to change the environment, a new competitor or some change in the existing product, everyone else reoptimizes. So you get a new equilibrium. And that's also a skill set that most people don't have and is really hard to do. So let me give you two examples of this problem. So one would be consider the business model of browsers today. The browsers you see are either sold with a device, sold with an operating system, or supported by a foundation. Okay, so now Tim Wu says, let's divest the browser. Well, I'm very curious as to what the business model Tim has in mind. I'm sure he studied this carefully, being in a law school rather than a business school, what the business model of a browser would be if it were freestanding. It's like asking a company to divest their accounting department. Great, now it's a freestanding accounting department. What's it going to do? So you need to, does it go and find an operating system to attach itself to? Does it go and find a hardware maker to attach itself to? Or maybe is what we have in mind that we want a third really extractive model that's harvesting our personal information and selling us advertising. That could be what the business model is. If you thought about divesting something like Android, by contrast, it's an operating system. It can just charge a license fee. So it has a very obvious revenue model. So that like, what are we, so that is a problem when we think about the new world. We have to think about, what is this entity going to actually do? How's it going to support itself? And then what will that generate? Interoperability is another one that requires creativity, because you might ask, well, who wants interoperability? This is a question I often get. Nobody wants it because they're all really different. Fiona, you're trying to make Signal interoperate with Facebook or something. And what you have to think about there is, who do we see in the marketplace? We don't see in the marketplace anybody who wants to interoperate. Imagine going to a venture capitalist and saying, I want to be just like Facebook, only better for people's mental health. It's going to be otherwise exactly the same product. I'm going to enter, there's this tremendously strong network effects, please loan me money. That would, no venture capitalist would lend you any money. If you said instead, I want to do something different, I want to have only 128 characters, or I want to have something that's about jobs, or I want to have a place for people to watch videos. Okay, now you're different, and you could compete, and I could lend you some money. So the parties that we see in the marketplace are exactly selected by the marketplace to not need to interoperate with Facebook, because that's not a thing that's available. So that tells you that if you were to change the interoperability rules, you would be doing that for a set of firms that don't yet exist. And would you be creating the incentive and ability for them to come in? So that is an exercise, again, that's this imagination kind of exercise. It's easier to imagine the vertical interoperability case, because we see the apps that want to interoperate with the App Store and don't like the terms or aren't allowed to in the way that they want. So a lot of those businesses do exist that want to, for example, be on a platform and interoperate what we call vertically. The horizontal ones, we tend not to see unless it's, of course, available, like email, where ISPs can interoperate, and you can change ISPs and still have access to the whole network. Or your telephone, where you change from Verizon to T-Mobile and you still have access to the whole network. But those are settings where there's some kind of regulatory or industry constraint that makes those parties interoperate. So I'll stop there, but just say that I think that you need the remedies to restore the lost competition. Restoring the lost competition means envisioning a marketplace that works with competitors. Therefore, you need incentive and ability, and then you need to think through, after you've created the incentive and the ability, who is it who's going to be attracted by your rules, and then how are they going to compete with one another? And that is a much harder cognitive process than much else we do in antitrust enforcement.
Good. So I'm going to follow on that, I think, pretty nicely. So we're not doing slides, so I brought a few artifacts. So artifact number one is exactly about the business model of the browser. This, if you don't recognize it, is a magazine. This is PC Magazine from March of 1996.
Wow. You just had that laying around?
I have a book I'm writing, as someone was nice enough to mention. What was the title, Harry? Question
I
X.
forgot now.
Okay.
The Age of oh, no, wait a minute.
There are, thank you, yeah, do that, mash it all together. There are reviews in this of 30 different browsers, right? Top choice at this era is Netscape Navigator 2.0. But what's really interesting, it goes exactly to where Fiona was what was the business model of the browser? Netscape wanted you, imagine this, to pay cash for the browser. That was the vision. There were some free versions, right? Microsoft Internet Explorer was free. NCSA Mosaic, right? Remember them, where this all started? That was free. So, and some of the prices are astonishing, right? There was an era in which software was sold like that, and that was the original business model for the browser, right? I want to start there. Artifact 2. So Artifact 2 is a paper by these guys, Brin and Page, that they wrote for a conference in Australia in April of 1998, excuse me. The Anatomy of a Large-Scale Hypertextual Web Search Engine. The published version of that paper does not have the most interesting piece of it. The most interesting piece of it is Appendix A. Yeah. You get these pictures of Sergey and Larry. And Appendix A is on advertising and mixed motives. If you haven't read it, you should leave right now and stop and read it, right? They focus very much on the idea that there is an inherent conflict between running a search engine and having it advertising supported. And that it would be easy for someone running a search engine to bias results in subtle ways that would work to the detriment of consumers, but that would make advertisers happy. What is their conclusion? They say it's really important that we have a search engine that remains in the academic realm. And that's, of course, what they did. Well, that's not what they did, as we know, right? So eventually they head down that model. But we have to figure out what the business models are going to be. And like Fiona, and I'm very much with her on this, when we think about remedies in the antitrust speech, we're designing a competitive environment. That's what we're doing. So I'm going to take one more business model forward. So the great transition here, of course, is we were in a world of computing devices, and the personal computer was our only device. There's a world of phones that are dominated by who? Well, Nokia with its Symbian operating system, Research in Motion, BlackBerry with BlackBerry OS. If you look at market shares for those figures, for those firms in 2006 and 2007, they're enormous. Right? And we heard all this discussion this morning about network externalities and the like and the way that's fulfilling and how you can't displace those people and they get completely wiped out. And there are three competitors who want to do that. One is Apple. You know what Apple is? Apple is IBM 1964 of System 360, a fully vertically integrated business model, hardware, software all together. That's exactly what they do. Then you have Microsoft. Microsoft wants to sell you software if you're a handset maker, because that's what they were good at, right? They built this enormous business. That's why we're here today doing that. And then you had this other mover, Google with Android, who said, you know what we're going to do is we're going to give away the operating system, but it's going to come with a payment mechanism. And that payment mechanism won't charge consumers, it won't charge handset makers, it will charge advertisers on the other side. And you know what? One of those business models failed, and that was the Microsoft model, right? And so now we're in this world where the firms that we want to go after are the firms that actually succeeded in the marketplace, and they have their market shares because that's what the public wanted. All right, I'm going to say one other thing, and then I'm going to stop. So as we think about Remedy 2, there's this line in the antitrust world that we should deny the antitrust perpetrator, the monopolist, the fruits of their labor. Google has a market share, as the case starts to talk about it, Winston's testimony starts with an 80% figure in January of 2009. If you look at those figures, that was a world, go to StatCounter's fantastic, right? That was a world in which almost 100% of that activity was occurring on personal computers. Now I'm going to tell you, here's the transition that's going to take place, and there are going to be two of them. One is somehow Internet Explorer is going to get displaced by this new product, Chrome. The second one is that Apple and Android, Google, are going to win the smartphone operating system wars. Now ask your question, in that world where that competition takes place, what do we think Google's market share is going to look like? Is it going to go down from 80? No, it's going to go up, right? Microsoft was incredibly well positioned before all of this happened, and Google had 80% of the market. So when we think about a remedy, and I have more thoughts about those remedies, but I'm clearly out of time, I want to focus on the marginal fruits. And what I mean by the marginal fruits are the actual illegitimate fruits that come from the behavior that we find to be a Section 2 violation. All right, I'll stop there.
Thank you. Thanks. I'm next. Can I reserve an extra minute to respond to what they said?
You already took half.
All
Let's
right.
see.
I took 3 seconds. All right, so let me get into it. I think that any student of antitrust remedies should also be a student of economic history, and should be very interested in the civic history of, specifically government, the whole history of remedies, particularly in the tech space. I think we're talking about tech here mostly, but also in related in nearby government remedies like the FCC's remedies, European remedies, and so forth. and their larger effects, with an eye to trying to understand as much as you can through history and what you see, what have been successful and what have been failures. I think this is a kind of conversation that's very easy to have in the abstract, but works better when you look at the history and what happened. And Microsoft's obviously part of that, the story of Microsoft and close analysis. But I think any reasonable look at this subject focuses very heavily on the AT&T 1956 consent decree, on the IBM litigation, also on Microsoft, the big the AT&T breakup, obviously, and also the various history of the FCC's interventions into these areas, more successful, less successful, and so forth. Because many of the FCC's decrees and rulemakings look also like antitrust remedies. I'm a believer, I'm going to talk about another paper. I'm working on a monograph entitled Antitrust as Industrial Policy, and I think that this country has, effectively conducted industrial policy through antitrust over the last 50 years, or maybe 80 years, particularly in the tech space. You could also call it just national economic policy, but in many of our areas, like computing and now like telecom, as opposed to sort of handing over money to the most powerful entities in those areas, we've sort of taken the opposite approach, which is to try to negative out the exclusionary effects of the monopoly on their industry and also adjacent industries. So I think of antitrust when it's industrial policy as sort of like industrial policy with a negative sign, traditional industrial policy with a negative sign in front. Instead of subsidies, you're sort of negating out exclusionary effects. Okay, so that's a point I'm interested in. So if you look at this economic history and you think about antitrust in these terms, what are the marks of success? What are the marks of failure? I've spent a reasonable amount of time looking at this, and I want to give a plug to a great book called The Quest for Next, which is a terrifically...
Convert by convert.
No,
okay, go ahead.
I have read many of the, 1,200 pages.
850.
Sorry.
Please.
You must have edited, you must have brought it down a bit. No, I think it's still there.
Made the font.
But no, it is a great resource. It's very important to have this kind of scholarship for the reasons I've said, is we need, people who are doing this. It's sort of like, we're almost like generals who don't study former wars and say like what worked or didn't. We need to figure out what we did and what worked and what didn't. And, when I look at the history, I think three things are the hallmark, and they're often different than what people want, but the hallmarks of a successful remedy, intervention, often look like this. Very often it's less the market that was the subject of the antitrust litigation itself, and as opposed to the growth and birth of adjacent industries that were for some reason being suppressed and people often didn't predict that. Software, coming out of the IBM litigation through the early settlement, wasn't even an official settlement, but the early agreement by IBM to open up software. The IBM 56 decree, keeping AT&T out of computing. You see a big jump in the computing industry, obviously more than one factor, and semiconductor industry, thanks to the licensing of the transistor. So, often the success is measured in these, how do you measure, compared to, say, breaking up a cartel, how do you measure the value of having a U.S. semiconductor industry, having a U.S. computing industry, having a U.S. software industry? Those are the big fish. Let's not mess around with little markets here. Let's invent new markets and new industries, or create room for those to grow. And those are the trillion-dollar prizes. Forget about this messing around with million-dollar settlements. So if you do that, if you have any chance of, and look, it's not easy. I'm obviously cherry-picking the most successful examples of the last 70 years. But that's what you should be aiming for, is something that opens up an industry, frankly, that no one knew, or people suspect it. Often there's like a cottage version. Like there was software during the 60s, which is this, piddly little industry, and maybe they got lucky. Another thing I'll say is a hallmark of successful antitrust remedies is industrial succession. one of the things I've been interested in is comparing tech industries like the computing industry, telecom, with industries like the automotive and aerospace, all of these, in my view, tech industries. The automotive and aerospace industries do not have strong antitrust interventions. In fact, the opposite. You have, what could have been strong, like blocking the Boeing McDonnell Douglas merger or the GM investigation, that don't happen. And when you look at those industries, the same companies are still there. The same guys are still there. There hasn't been the sort of industrial succession that you've seen in computing. And, like IBM's still there. They exist, but no one's like, oh, obviously, when we talk about computing, we talk about IBM. The way in aerospace, it's still Boeing. That's a sign. The final and kind of hallmark successful remedy is you have a lot of history of like people quitting their jobs to start new companies. You see a huge amount of this around 56 decree and semiconductors. So if you have a remedy, if I'm sort of speaking practically, ideal hallmark of a good remedy is people start quitting the incumbents and starting new companies. Whether they're starting browser, I don't know. But whatever it is, something with that in mind is very helpful. I realize I'm running out of time. Can I have my minute on the that I requested earlier, or do you want me to do that later?
No, you have 45 seconds. now.
Okay, I'll take that.
Okay.
So I generally agree with Fiona, but Randy. I think that I think that there is, however, some risk in trying to be too fine-tuned about what the business models are going to be, because I feel like the FCC has fallen into this trap sometimes, where they're like, all right, based on what we want to do, these are all the guys who are going to grow up to compete with AOL, like chat or whatever. You know what I mean? And you can be a little too fine-tuned
Yeah,
about it.
that's what I said you shouldn't happen at the beginning. Like,
Yeah,
Don't
so,
try
okay.
to identify your.
Yeah, well, maybe we don't disagree then, but I don't disagree. But I just think like there's some danger. I also think on this, breakup versus consent decree. There are obviously like 56 AT&T thing was a strong consent decree. So there are obviously strong consent decrees. The reason I emphasize breakups, and especially in public comment, is I think of remedies as having two stages. One is what you talk about, and then the other what you do. And I think coming into negotiations, I think enforcement agencies have to come in with structural relief to get anything. You know what I mean? So I think it's partially about how the agencies should talk about what they're doing. And if they're not talking about, it's this classic problem of centrist being exactly, here's what we want, and then getting negotiated way back from there. So I think agencies, as a matter of public speaking, have to talk tough when they're in negotiation mode. All right.
Harry, Andy, thank you for the opportunity to be here. When Congress in 1914 starts to consider upgrades to the U.S. system, one of the concerns they had is that in monopolization cases, individual federal judges might feel overwhelmed, that the burden of determining the future of a major sector, especially one with market power, might paralyze the judge and might cause the judge in many instances to shrink away from taking what would seem to be bolder steps. I think this was captured at a later time by Judge Wysanski, who in the course of one of his famous cases said, a single federal judge, I'm being urged to take dramatic steps that would restructure an entire industry. I don't conduct legislative hearings. I don't have the power to gather information in the way that others do. And I don't have the ability really to consult with colleagues in doing this. And he said, that's a lonely exercise. So Congress had a solution in mind in 1914, and it appears in Section 7 of the FTC Act. It gave individual federal judges, in the context of Department of Justice monopolization cases, the ability to appoint the Federal Trade Commission to serve as a master in chancery to advise the court on the design of remedies. Although that's a quaint term from ancient equity, the essential feature of it would be to be a resource for the court to think about what the content of the remedy might be, and I think in the background to also consider how implementation might unfold. and maybe as an extrapolation of that at some point to actually be involved in monitoring the implementation of the remedy. This would have entailed, I guess one feature is used once in the 19 teens, never again. So not a lot of body of experience. So I'm going to talk about what it might have been and perhaps what could be in the future. Not so sanguine as Slade is about the future of the Federal Trade Commission's antitrust mandate, but let's assume that it stays there. You'd really want the agency to do three things as part of this process. One is you want a complete view of what the doctrine regarding remedies has been in Section 2 cases. And there's a lot of it out there now. A striking amount of it was established in the 1940s and early 1950s in the context of cases involving movie distribution in theaters, for example, where courts had a lot to say about the appropriate standards for designing remedies in monopolization cases. A massive amount of experience in patent licensing cases, in cases like Hartford Empire, that have a lot to say about how you might design interoperability requirements, what terms access would be permitted on, a huge body of information that you want readily available and brought to bear. You don't want your team to be suddenly, in the face of a potential victory on liability, to be doing the research all over again. To pin all of that down. You want that body of knowledge available, as well as collateral knowledge that comes from the field of merger review and the implementation of remedies there. So you want the doctrinal framework down cold in the sense of how it's developed. The second thing you want is everything you could possibly know about actual effects. You want every company history that talks about effectiveness of solutions. You want every government study from every government agency everywhere located to bring that knowledge about the remedial experience to bear. And that experience is vast, as Tim was just saying. It's in the context of antitrust litigation. It's in the context of sectoral regulation and oversight in fields like communications and fields like banking, at home and abroad. So you want everything that's been done about remedies. You want the company biographies in particular that tell you how things unfolded. Everything from the vast literature on the petroleum sector and the actual effects and implementation of the famous Standard Oil remedy to matters such as the 56 final judgment in AT&T. Part of what you see as a footnote for the people who have to make decisions is how that remedy was ridiculed at the time it was taken. That was seen as a pathetic political sellout by the Eisenhower administration, which had sought the breakup and spinoff of Western Electric from AT&T, and the overwhelming chorus of commentary was pathetic capitulation. The DOJ officials who wanted that remedy saw a future in which good things could happen. They couldn't pinpoint exactly how it would happen, but they thought it would happen. They went to their graves where the overwhelming body of literature said you had been fools and you gave it away. That's a humbling observation for law enforcement officials who realize that maybe the real impact of what they're doing is well over the horizon. But they had a logic for what they were doing. It was not the only case in which they got a basic patent-related remedy solution at the time, but they had a larger view about how that could change industries in a transformative way. They went to their graves not being lauded for this. It's only much later that the chorus has said, good job. The other thing you see, I think, in these histories is the interesting intersection of public policy as well. You see how public policy in the form of other investments made a big difference. That digital revolution with semiconductors, the event that propelled semiconductors was the Apollo program, because NASA needed large numbers of highly reliable, relatively inexpensive semiconductors. They drove the demand for that product, running in parallel with the IP solution that was available. NASA's decision after the United Launch Alliance is formed to realize we want an alternative to Lockheed Martin and Boeing to provide launch vehicle services, that caused them to give some support for SpaceX, as well as Musk's own investment of what he earned from PayPal. And I think it also gives you industry biographies that I think give you a different view of what happened in some of these sectors. There was major antitrust intervention in aerospace that's made a great difference. The blocking of the Lockheed Martin-Northrop merger set Northrop down an independent path where Northrop becomes a leading producer of uncrewed vehicles, drones. And you see today, government spending money on drones, which means that the leading force for smaller drones, which are force-changing introductions into the defense sector, it's all coming from small entrants. It's not coming from big firms. That, in many ways, was an effect of public policy. So you see in an interesting way the interaction of private decision-making, government intervention in the form of antitrust cases, but also government investments that provide an enabling environment for success. The last thing you see is a huge body of information on actual policy implementation. How do you actually carry out a major divestiture? Is it difficult? Do companies land on their feet? How do you design licensing arrangements and access arrangements? Again, a massive experience that's available and out there, what might be called big antitrust learning and data, that can be brought to bear. You'd want an institution to do that. In theory, that was the FTC as the remedies agency. It still could be done. It's still out there and available. One would think it would be enormously valuable in a variety of settings for individual judges. It would inform the formulation of remedies in a way that's much more effective than what we go about doing now. And there are also other approaches that you could think coming out of this. The US could adopt a markets regime of the kind that the United Kingdom has that would allow the FTC to impose remedies of its own in the course of a market study. You might consider that if there's going to be an ex-ante regulatory platform for tech, that ought to be the FTC because of the intersection of three policy domains: competition, data protection, and consumer protection. There is one government agency in the world that does all three as part of its portfolio. That would be the Federal Trade Commission. So in thinking ahead about how to go about carrying out remedies, I think there's a crying need for the institutional capacity and approach that was built into Section 7 in the original conception of the FTC Act. That would be a source of enormous confidence, I think, to courts in making decisions about how to go ahead to allay the concerns that Charles Rosansky spoke about and to bring to bear an extraordinary body of knowledge that we have about competition-related remedies, remedies from other fields of activity, and the way in which they intersect with other government policies to make entry and expansion possible, and yes, the creation of entirely new industries.
Okay, thank you very much. What we have done with Pierre is try to have three main lessons from the two Microsoft case, the one we had here and the one we had in Europe, and the two Google case that we have in Europe, so the search and Android. And basically the problem was the same. It was an incumbent which was cutting path off at intermediary level for newcomers, for those creativity, as Fina would have said, or those adjacent industry. As Tim was saying, and so the question is how you fight those incumbents who wants to cut back. And going to those four cases, we think that three main lessons can be learned. The first is we should focus the remedy on the user side instead of going on the OEM side. And that's coming very well if you contrast what the US has done in the Microsoft case. The consent decree had a lot of things, but one thing which we think what was the most powerful or the most effective was to open the possibility for users to switch on competing software for certain operating system associated program. So it is the possibility of the user to switch. While if you compare what has been done in Europe with the first Microsoft case, the one with Windows Media Players, and there was you may remember this forced offering of Windows without media players, and that was a failure. And and Bill will be happy to learn that because DG COMP has launched a new study on the effectiveness of remedy this week. So they have done
Thomas
go back.
Dazenover's
Exactly,
study, yeah.
And they say about that remedy that it was a commercial failure and unsuccessful in terms of effectiveness. So I think if you contrast the two, you can understand that the Microsoft here was much better than the Microsoft at our place. Now, if you then go to the next Microsoft case, the second one in Europe, the Explorer one, where we had the choice screen, that was in a way a better way because it was focusing on user instead of OEM, but still there was some problem, and that's why we can learn the second lesson that Pierre will mention.
second lesson is that if we focus on the user side, we do need to have a more refined view of the different types of end users. So they're not all the same. So here, I wish some economist colleague would help us turn this into a proper model. But if you put an incumbent, a newcomer, and two users, and one is, we'll call geek. So that's the person who seeks the state-of-the-art solution, cost what may, and normie. And normie is happy with the default solution as long as it's not too bad, because it's too complicated to switch and to ask yourself, what should I have? This model can work as long as there's an ability to switch to other providers. So a geek can move along and decide what he or she wants to use. And there needs to be the ability to communicate between geek and normie, so that geek can say at some point to normie, I know you don't want to switch, it's too complicated, but you're really missing out on something much better. So normie knows, I will get something that's not too far from the state of the art, because if it gets too far behind, then someone will tell me you need to switch. So you need the ability to switch, but you also need the incentive, the ability to communicate. And that's how we can see why the EU failed. I think the OEM level remedies in the Microsoft Media Player case essentially assumed that all the users were normies. So we just take what the OEM manufacturers decide to give us. But the choice screen remedies that we have in the second Microsoft Explorer case and also in Google Android, they assume that all users are geeks, that we just cannot wait to have the ability to choose. And as we know, many users are just overwhelmed or don't know what to choose. And in that sense, the Microsoft consent decree really found the sweet spot with the changes that were brought with Windows SP1. And when you look at it, this consent decree applied to a number of different programs, and it supported different solutions. So in the browser case, yeah, Internet Explorer was displaced by better browsers. In the email client case, not much happened. So presumably, Microsoft managed to have a decent product going forward. And in the media player case, you have disruptive innovation. And that's neither nor. So Apple came along with the iPod, and all of a sudden, the media player was no longer where the game was. It was just a program you needed on your computer to operate or to communicate with your iPod. And the consent decree allowed for all three scenarios to happen. The problem is it may not be replicable in the Google context. The Google context is more complicated than 25 years ago. And it's not just a question of being able to switch, it's also the question of communication, being able to signal to the normies there's something better out there.
And so that leads us to the third lesson and allow us also to bring the DMA into the picture, because we think that when you have some behavior remedy which are complex, maybe a regulatory system may be better, because it has at least three advantages. Not only that it is quicker, because often the DMA, the rationale of the DMA is presented as we want to have a quicker antitrust, but I don't think that's the main advantage of the DMA. I think we think the main advantage of the DMA is that it's better at dealing with remedy, and in particular at three aspects of this. The first is to design the remedy, because you do it in a way of involving all stakeholders and in a way of having a discussion among the different stakeholders. Now, I must say that so far, the DMA enforcement is not that good at that, because unfortunately, I think the Commission still has much an antitrust mindset when it designed the remedy, in the sense that the Commission goes to the gatekeeper, discuss with them, and then goes to the business user, discuss with them, but don't put everyone around the same table, which is normally the regulatory approach, okay? But, I mean, it's a learning process, and I guess the Commission will learn. The second thing is to monitor the remedy and to monitor compliance, and I think a regulatory authority which in constant contact with the regulatee may be better able to do this monitoring than clearly a judge or even an administration which is doing antitrust, which is more an hit and run strategy in the market, I would say. And the third, and which is very clear here, is to adapt the remedy from what you have learned, So basically, we think that because of those advantages in the remedy design, monitoring, and adaptation, a regulation may be, or regulatory regime may be better adapted than an antitrust regime. Now, the last question is, what will happen with the DMA enforcement with the new administration here and in the UN? The big risk, as we all know, is that everything become politicized, and that the Commission, because we should remember the Commission is also the government of Europe, will politicize the enforcement under the pressure of the Trump administration. I hope it will that's not what will happen, but I'm not sure, because if you see, within the Commission, clearly now the enforcement have been centralized in the hands of the President of the Commission, von der Leyen. And also there are some talk about a grand deal with the Trump administration on digital and something else. I think it will be a mistake, but it's a possible scenario.
Well, I was interested in politics, but I didn't think of that part of the politics. But then, now we control everything. Okay. So first, reactions among the panelists of things that people want to react to. So,
Yeah,
Okay,
I'll say
Fiona,
one
yeah.
thing about the DMA. I do think it's an understudied instrument in the United States. It creates, rather than saying we're going to try to get rid of these dominant platforms, instead it creates some certainty of rights for the business users on those platforms. And those certainty of rights are things like ability to contact your customer, ability to extract data, the rights for the end users to switch and bring their data with them, and interoperability rights. So the right to have a digital wallet or a app store or whatever. That's a very, it's just an interesting approach, because you might say, well, it's not busting up the existing monopoly. I think there's a lot of people who'd find that disruptive. And then the second thing it does is it gives that certainty and freedom to invest on the part of the business user, which then might get us the next platform in some amount of time. So, and I think that's an underappreciated element of the interoperability too.
I mean, I want to comment also on the European remedies. And I appreciate this, approach of trying to figure out what failed and what has succeeded, and I think that's key. There is really a lot of overlap with telecom style remedies in that, and Slade was talking about how he thought of the Klobuchar bill as like Telecom Act for the internet or something along those. Sorry, it is already covering the internet. Telecom Act for platforms or something like that. And these things are very hard to do well. And as Fiona was just saying, the real challenge is creating a real stable set of rights that people can invest in, as opposed to creating dependent businesses that can be sabotaged or constantly, at the mercy of the platform owner, or in telecom space, it's, the incumbent. The 96 Telecom Act was, in some ways, a little bit like the DMA, in the sense it was trying to create a possibility for, and I don't want to go through, for competitors they were actually supposed to be direct competitors. But in any way, I just want to say it's a lot of skill that goes into it. And if I could pick up one thing, it has to, in fact, I'm a little skeptical of user-centered things. I'm sorry to say it. I think roughly, I don't strongly disagree. Obviously, the users are very sympathetic and ultimately have to be the ones that, go to a competitor. But ultimately, it is, I guess, the dependent businesses, when we're talking about platforms, and I think this is why when we talk about Google, we're going to have a very sophisticated understanding of platform models and two-sided markets. When we're talking about platforms, it's really the dependent businesses who are going to have to be in a stable enough condition to offer things that users actually want. You know what I mean? And I don't think that disagrees with what you're saying. I mean, the whole sort of design of the internet and why it was so successful, or eventually of the IBM platform model, or the Windows decree, was that the dependent businesses were able, say like Google or Facebook, to operate on top of somebody else's business successfully and actually offer things that users wanted. So, was the Microsoft decree user empowering? I mean, I think the Microsoft remedy, I think it actually was empowering of Google and Facebook and all those other startups who were able to stably offer something that users then wanted. But it didn't say, hey, users, sign up for this thing or something like that.
I guess I wanted to take go ahead.
Go ahead, and then Bill.
The 1956 AT&T, I mean, it's hard to not talk about it when you get the chance. So,
Have you ever done a class on that?
yeah,
just
I
on
guess
that?
so.
I should have brought in my princess telephone, I
That's
was
what you
really-
should have done.
Sorry.
So I think Bill's dead right about the contemporaneous reaction to it. And so this is DOJ basically as Vincent van Gogh, only appreciated in death.
Yeah.
But I also say there's more to say, but it's a little critical of it too. So look, and that shows you the complexity of the whole thing. So AT&T was engaging in licensing of the transistor before the 56 consent decree. They had obligations to do so under military contracts. So they wanted a second source. They were doing some of that voluntarily. The original AT&T transistors are in germanium. Texas Instruments finds the future before 56 in silicon, pursuant to the licenses they'd voluntarily gotten from AT&T. So the causalities there, I think, is really tricky and complex. The other thing to say, of course, about the 1956 decree is, by keeping AT&T out of the computer business, it made it easier for IBM to run away with it in 64. So you see the yin and the yang there. And then, of course, the 56, good, Tim's going to respond. Then, of course, the 56 settlement, final judgment, plays powerfully into the 1982 AT&T breakup, because AT&T wanted desperately to be free of it to go into the computer business where they could lose billions of dollars repeatedly. But that's how competition works. That's how competition works.
I think it would be so useful in thinking about the remedy in the next case to be aware of this flow of activity.
For sure.
And possibilities. and
Good
to
thing
think
there's a
about what-
book.
Thank you so much. What's its name? Okay. Yeah, well, thank you. Boy, my publishers are going to be happy today. Okay.
Yeah, they got 3 more sales? I don't know. It's a-
Thanks, exactly.
To Fiona's point, if Judge Mehta was inclined to do it, I'd give a slot in his remedies proceedings to officials from Comp and Connect to come in and talk about the DMA experience so far. To say, I realize it's a different set of commands, but you have some precious experience now in trying to roll this out. You have experience already in thinking about the adaptation that takes place on the part of industry. You have some experience with what the firms have said they can live with. I'd like to know about that. It won't be transposed directly into anything I do, but that is a valuable perspective on what I might do here. And I have the sense that in what he's written so far about remedies, he's anxious about the immediate adaptation will take place in the face of anything that he imposes by way of a decree. And I think there's almost an acknowledgement in the DOJ remedies documents that there has to be some inherent adaptability and scalability in the remedy, almost to the point that, I don't know what the right word is, that you might have to reopen the proceeding at some point in the future to come back on how it's working, how it's turning out. But I really, one way that I would think of to put Fiona's excellent insight about the DMA experience, but if I were Judge Mehta, I'd say, I'll give you a couple of hours to come in and tell me about how it's going. And if you want that to be done in some confidential fashion, it's awkward, sensitive, I understand that. You can talk with me, the court, about how to do that, but I want to hear about that.
No, I
You're
just
going to
want,
speak up for the DMA?
no, I just want
Oh.
to act on what Tim say, and it's true. I mean, I see the DMA as a liberalization law, a bit like the end of the Berlin Wall, but for cyberspace, if you want. And
Which was more important, do you think?
I don't know.
Yeah,
I don't know. But nothing is taken
Ask
for
Angela
granted.
Merkel, yeah.
But the thing is this. I mean,
We won't know
clearly,
for decades, right?
clearly we needed to do a study on remedy on that. No, but clearly the thing is that we need both. I mean, we need some new business arriving with that certainty, and the user having the confidence, and they have to learn to choose, because this is something we were not used to do. We are not used to do. At least the normie are not used to do. So I think indeed we need both for the things to be effective.
Don't you want to feed back into what you're doing, everything that's coming out of the records of these trials, which say a lot, maybe much more than we knew before about how the companies operate?
We have until 3:30.
Can I talk about
one
The Google
one
thing,
minute.
or, no, I want to talk about,
Oh, you want it?
I don't want to respond anymore, I want to
Okay,
talk
go.
about Google. so.
I was going, I was, I was going to
Viewpoint
bring,
discrimination at
I
some
was
point.
going
Yeah.
to bring, we have a great discussion of the past, study everything, look to Europe, do all of this stuff. I'm just sitting here thinking, so what do I do in these damn cases? You know, we've got 5 major cases. Remedy, well, I'm just talking about the platform cases. There's Visa
I'm
coming,
sorry.
there's, you know, the PBM's case. What do we do? And it's nice, you know, Learned Hand sent corn products to the FTC. They never even did anything with it. It was
No,
finally
they settled,
right?
they settled.
It
they
was
settled.
settled, right, but.
They settled,
but
the
this
FTC
Court of-
started to work
This
with the
whole
settlement.
chancery
Yeah.
thing,
So,
great, we
Harry,
can study everything.
I've
But-
got 2 answers for you.
Wait, oh, hold on, I haven't even posed a question, Fiona.
I
was
just,
waiting-
I just,
I was-
I
what
just
should
wrote
we
papers.
do?
Yeah, so
Okay.
I have a paper with
So,
Michael
I wanna
Kadish
hear-
for
but-
Facebook.
Okay,
That's
so-
it. And I have a paper about Microsoft, sorry, about Google.
Okay, so I want to hear the quick reactions to, what do we do in these cases? Do we divest, and from some of the things I've heard, so do we divest Chrome, Android, and tell Google that they have to sell their stock in AI? This is in the request, hold on. I love it when they're champing at the bit. And I want to hear why the Vice President of America is wrong in saying that viewpoint discrimination is not something to consider in an antitrust remedy case. So,
I just
reactions,
have
Fiona,
very
did you want
short.
to say something?
I
Go ahead,
did.
okay.
The Facebook remedy, Michael Kadish and I have a paper that's not yet published, but it's on SSRN. And then for Google Search, I have a paper that's up on the Yale Tobin site that's with a number of co-authors. And I would say that maybe the interesting thing in that paper is to point out that if you just tell Google, stop stop requiring OEMs to put Google Search onto the handset, you can tell them that, but the handset maker has to have Android or else they can't sell a phone. So there's just so many ways that Google can force search to be there, from either charging for Android or saying you're going to get your updates a little late, or we're not going to guarantee that your build is approved on time, or whatever it might be. So that motivates us to suggest that divesting Android into some kind of standalone entity that licenses would leave the OEMs free to negotiate over search without the threat of not getting an OS hanging over their head. But there's a lot more in the paper.
I guess I want to go after the viewpoint discrimination.
Yes.
So, look, I'm not a First Amendment person, but man, I've listened to a lot of it over time at the law school, which is fantastic. It's one of the great luxuries of being at a law school, that you hear all these ideas. So look, private entities have First Amendment rights. U.S. citizens don't have constitutional rights vis-a-vis those private entities. They can discriminate against viewpoint discriminate against who they want to. I don't think it's an antitrust issue. That's what Tim said earlier, I think, but we'll see.
Yeah, no, I kind of agree with you. I think it's an outlandish, and I don't, I rarely, I have a less, it's not a First Amendment conference, but yes, I think that threatening, use of the antitrust law to threaten people to get the speech you want is not the kind of thing I think is completely consistent with the First Amendment. How's that?
Yeah.
So,
2 votes, okay.
yeah, on,
Down here as well.
3, okay,
I said it was a slight amount of hesitation because I do believe there is such a thing as common carriage laws. You can tell AT&T to carry everybody's phone calls and have that not be a violation of the First Amendment. So I have a
Wrinkles.
slightly more subtle position. Yeah, I don't think common carriage laws, which force AT, have generally been understood to require carriage of fair and even carriage are so okay. But that's different than trying to impose what you want in terms of speech policy on entities. As for these remedies, I'm going to bring up another book, Master Switch, which is a book I wrote
Who wrote, oh, okay.
15 years ago. And that book was about succession.
Is there an author's table out there?
Yeah, I know.
Just bizarre for
yeah,
money?
we missed we could put our book
somehow
out there.
like whatever instincts of mine that were anyway. So that book was obsessed with succession And I think that, antitrust remedies are often a moment for the birth of new industries and also for succession, as I talked about. And from that perspective, it seems that maybe the most important remedy, if we look back at it 20 years later, would be one, and this is for all these cases, that allows the AI industries to emerge as a challenger to the platform industries. I mean, somehow people are sort of taken for granted. This is as if we're in the 60s, and we're like, well, of course IBM will control software. Let's just let it go. Or, of course, AT&T will control computing or whatever that is. I think successor industries, have a lot of vigor, excitement. And, it seems like a heavy lift right now to try to not have the platforms control the top AI companies and efforts. But if there's something that would make a lot of people quit their jobs at platforms, I think it would be to go into AI, based on my third criteria, what makes people quit. I think we see some session, and maybe we see different approaches. The platforms, consistent, this is sort of a Kenneth Arrow point, or many other scholars have made the point, seem determined to want to make AI into a complement to their existing business models as opposed to any kind of substitute or challenger to it. I'm reminded a little bit of Western Union, who had their own telephone, had Thomas Edison design it, and had a great business plan, which was the telephone would be the technology that rings your house to tell you a telegraph had arrived, so you could go get it. That was their vision of where the telephone, and that's where I think a lot of AI is, like right now, in the platform. We don't realize it, but when you say, well, that what AI is going to do is going to make, help search better, or help Amazon answer your questions about products, that's maybe limit. It is limited, and it's like adjunct. And so I think whatever this remedy does, if they create industrial succession or create the opportunities, I think that's very important.
So we have a vote for that clause in the proposed final
Yes.
judgment.
Yes.
I agree.
Yeah, I have a clause in the methodology. The request for the clause is simply a careful specification of, and maybe it's an explanation separately, of the expected effects of the solution that's chosen, with the assumptions laid out, with the recognition that if you could make precise and accurate predictions about all of that, you'd be doing something else for a living. But I think to have that laid out so that all of us can keep score over time to see how it's going, along with the mechanism that is built into the DMA that says we are going to have an ongoing assessment of how this works. That was in the AT&T decree in '82, and to have that built in from the beginning. And the other thing I'd like to see part of the process is how many Google Matters are there running now around the world? It's a lot. I'm trying to remember the academic at Copenhagen who tracks all of them. In a way, with each new measure, if you think of a regulatory ecology, you have existing plant species there. Each case, each intervention adds another into the field. And I would think a question that you'd want to ask yourself as you're doing it as best you can is, what happens when they add the next one? Will they interact at all with each other? What's the consequence of adding it? Is there a way to design it in a way that might take the best advantage of what's already there? Those would be my other requests for the
So
proceeding.
periodic status reports.
Yeah.
We're sounding a lot like the
And-
Microsoft decree that
and-
we
and-
had,
and
which is fine, right? And
Regulatory ecology.
Okay, we don't do
Awareness.
this for mergers, as we know. We
Wouldn't be a
have
bad
all
idea
these.
there.
No, wouldn't be, but we've got a lot of good ideas. And it's wonderful and a
That's our
problem at
business.
the same time, right?
I mean, I like this idea of the law of succession, the antitrust as a law of succession. And in a way, that's what the DMA is. It's try to open the digital ecosystem to allow a successor and ideally a European successor to come. So, if we can manage to have those people quitting their job in the US and coming to Europe, I mean, that would probably be the best success
All
for
of our
us.
government bureaucrats are going to do that. Okay. You, Pierre?
Just wanted to add on the exchange of experiences. So one advantage that the US authorities have over the European ones is the approach to remedies in Europe it's very much informed by the continental public law tradition. And it's the authority says, this is what we want, you go figure it out. And you expect, that's the meaning of the special responsibility of the dominant firm as well. The firm just takes it to heart and does the job. Now, that's no longer how it works, and that's a tough learning experience for the European authorities, which the authorities here are more accustomed to do. And on the issue of the viewpoint discrimination, one thing that it would induce for sure is a massive problem for the firms to comply with both the DSA and what will happen in the US. Europe goes in the exact opposite direction.
By the way, I would add a footnote that a number of the things I've been talking about will require effort and money. And if the current plan to go ahead with the dismissal of all probationary employees in the federal government is carried out, that's probably at least 100 to 200 people at the FTC. I don't know how many at DOJ. Along with the decapitation of the top layers of management, they'll be struggling to do even the most modest basic tasks, much less do the more grandiose and significant things. And that's no joke.
This is the appropriate, don't we have some good, I wanted to end actually on an observation that Steve Jobs had about the importance of the Microsoft litigation on innovation at Apple, is quoted in Walter Isaacson's book. Him telling Joe Klein, look, just tie Bill Gates up a lot in all this antitrust stuff and keep them busy in that, and we'll do the rest. I leave you with that observation. Thank you very much. And thank you, panel.